But of course, the thing that we want to talk about today is the motion to dismiss Gina Carano's lawsuit being denied. And in order to talk about that, we need to bring on someone. By the way, you need to go check out this guy's YouTube channel. He is a legend. And when I say legend, for those of you who think that we might engage in something called hyperbole or puffery or something like that, this is a man, first of all, he protected free speech on the internet for us and therefore everyone else in the space, which is very important to everyone in our sphere here. He's also argued cases successfully before the highest court in the most important nation in the world. That would be the Supreme Court of the United States. Also, he's got a wicked sense of humor. Let's bring him in, Mr. Ron Coleman.
Hey, guys. How you doing?
So glad to have you here today, sir. I know that we don't have you forever. You doing well?
I am doing well, and I have really enjoyed this decision.
Wasn't that a wonderful document? I watched legal, last night, go through it line by line. That judge, she's a card, isn't she?
A card? I mean, I think it was a pretty
it was very straightforward, but she really got in all the details that mattered to anybody who hasn't been following this to say, all of this is answered by what? A specious free speech claim? You got to be kidding me.
Yeah, she really did a thorough job, and it was a real refreshing experience to hear something coming out of the Central District of California that actually acknowledges that studios and media companies are not the only ones with legal rights.
Yep. So I have questions, and you know more about this than I am able to perceive all the questions that I should be asking here. So here's what little I know. You're not on the stand here. You are our expert witness. Therefore, you are allowed to say whatever you want. You don't have to be restricted to yes or no here. I see that this is 23 pages. And if we're talking about, first of all, her recounting of the arguments here, once we get to page 9, I believe this is where she starts to lay out her take on it. She being the judge, whose name is Peace, which is a kind of a hilarious pseudo-religious statement right there. But her name literally is Peace. Is it usual for a judge to have such a lengthy opinion? Sherilyn Peace Garnett, by the way, for those of you who don't know what I'm saying there. Is it usual for an opinion like this to be that long?
Well, yes and no. It is very common in the federal courts in California for courts to issue short memorandum opinions, which are basically previews of the opinion that they're going to eventually issue, and sometimes are meant to signal to the parties maybe they should reconsider where this is going before it gets official. Here, that didn't happen. Here, the judge took a little bit more time and wrote a fairly detailed but not over the top decision, which is a little bit probably longer than if one of us sued someone else here on the panel over the same issues. There's no question that
I'm reminded of your response on our behalf to Black Girl Gamer.
Yeah, well, sometimes less is more, but the judge is cognizant of the fact that there's a very good chance that this is going to be appealed eventually. And this is federal court. There are no interlocutory appeals, meaning that because this is not a final order that disposes of the case, if the motion to dismiss had been granted, it could have been appealed immediately by Gina Carano. But because the motion to dismiss was denied, the case goes into discovery now, and no appeal is possible until a final judgment is entered. It is possible in theory. The rules provide for Disney to ask for leave to appeal an interlocutory order. I wouldn't say that that's impossible, because they may argue that it will be the end of the world if you're wrong, judge, because the First Amendment is super important, and the judge is not likely to grant that. It is possible for a party then to go directly to the Court of Appeals, which is the Ninth Circuit. And the Ninth Circuit is, I'm glad to say, a little bit more of a mixed bag than it historically has been. It is still trends rather on the liberal side. But this judge has the liberal bona fides that I don't think they're going to be too quick to dismiss it. And it's really unusual to get leave to appeal an interlocutory order like this. Now, I actually want to address something else that you said, Jonas, about the recitation of facts in the case. It is fun to get right into the legal discussion, but the facts are really important. And she makes that very clear in the legal discussion because she distinguishes the facts in this case from the cases that Disney relies on.
Yeah.
Equally importantly, what you see the judge doing here is tell a story that very much sounds like the story that Gina's complaint tells. I'm sure that the facts, let's remember, this is a motion to dismiss under Federal Rule of Civil Procedure 12b-6, which means everything in the pleadings is considered to be true if plausible. For purposes of asking, if all this were true, would there be a legal claim here?
Right. The idea there being that it would be decided in court if it were or were not true.
Say that it would be decided.
Is it assumed plausible because that would be a matter for the court to decide if it was not plausible?
Right. In other words, when I first started, the test wasn't plausibility. It was if there was any literally possible way that the pleadings could be true, the court had to accept them as true. And in a case called Twombly, the Supreme Court said, all right, there's a limit. We don't have to accept things just because you say them. They have to add up internally to some extent. But what's important for people to remember is that the court was not weighing the evidence here. And in fact, one of the points the court makes not once but twice in the course of the opinion is Disney has asked us to accept its version of the fact, and particularly facts concerning what its motivation was for firing Gina, and facts concerning how Gina's comments might affect the creative product, the expressive product that Disney is putting out. And the court said there's nothing in her allegations that is inherently implausible. And she reminds the reader that the Supreme Court has taught that when there are two plausible theories of why something might have happened, it's not the court's duty on a 12b-6 motion to merely say, well, I find one more plausible than the other, which courts do. They're not supposed to do it, but they do it a lot. They did it to us in the same court when we sued Twitter on behalf of DC Drano. Basically, the court said, you've got a lot of evidence, but we don't believe your take on it. Ninth Circuit affirmed that, and the Supreme Court denied certiorari a couple of weeks ago, much to our disappointment, although we weren't shocked, but it was disappointing. Here, the judge saw something she likes on Gina's side and something she doesn't like on Disney's side, and she did recite the allegations in a way that made you feel, by the time you got to page 9 and the legal discussion, that something wrong has been done here, and I hope there's a way for the court to help Gina get some justice.
Now, the question that I know is going to come up, because I always like to go to the pushback first that we get. This is a federal case, but it is being bound in some ways by California law. Can you speak to that a little bit?
Yes, it is a federal case under the doctrine of diversity, because Gina does not live in California. I think Montana is the last. Montana, okay.
Not that I know.
Okay, that would make sense, because otherwise this would be an entirely state court proceeding. But
though, of course, she did live there when all this was going on.
Right, that's right. But and that is sometimes a factor. And if it looks as if someone has moved merely to achieve jurisdictional diversity, that can be raised. It doesn't seem to be the case here. That doesn't seem to have been an issue. And after all, given the way she's been treated by Hollywood, why the hell would she want to stay there?
Fair point.
Well, but I was saying it affects the part about her physically being in danger during this going on, because people were stalking her and camping out outside her home and everything else.
Oh, that's a good point. I mean, the court mentions that in passing. It isn't a particularly meaningful part of it, but it does paint, and it does add what we call color to her description of what she went through and how Disney's cultural war against her and mimetic and social media war against her and
I think we're having
affected things.
I don't know if it's just me, but I'm having a little bit of an audio lag issue. We do have a question that's coming up. I think this will be a pretty easy one for you to answer, but I've seen it come up several times. Does Gina get some slap protection?
Gina is the plaintiff here. So SLAP, as Dice knows, is strategic lawsuits against public participation. Anti-SLAP laws prohibit someone from suing another person under the rubric of defamation or some other kind of tort when all they're really trying to do is shut them up and prevent them from exercising their First Amendment rights. Because she's the plaintiff, anti-SLAP doesn't apply to her.
Right.
So,
interestingly, although Disney made a claim here that Gina's claims were barred by the First Amendment, they did not bring an anti-SLAP claim against her, which would have, as you can see from the outcome of this decision, gone poorly indeed. But it's important to understand that the California state statute, the Unruh Act, which prohibits taking any kind of adverse action against an employee based on his outside political or other expressive activities, essentially amounts to what you would be looking for in an anti-SLAP remedy, except that in a case like this, it benefits a plaintiff.
This is a very small question here, but if they decided
there are no small questions, only small question askers.
And those who have met me in person know that I am not a small man here. So the thing I want to ask is, if Disney countersues with some kind of defamation thing, does that open them up to anti-SLAP, even though it is a countersuit?
It does, absolutely. I'm just curious. In fact, I lost an anti-SLAP motion based on counterclaims early in my career in California. I argued, as I actually still believe, that it was unconstitutional for California law to regulate what I could claim in a federal court. And there are many legal scholars who agree with me, but none of them is a member of the Ninth Circuit Court of Appeals, as far as I know. I lost track of the question.
That's all right. Would they open themselves up to anti-SLAP if they decided
that would come about as a result of what her claims outside of court trashing Disney?
Well,
you certainly can't sue someone for defamation based on what they file in a lawsuit and claim against you. That's absolutely privileged.
That's one that I feel like our audience has a lot of questions about, because that's come up, well, specifically around this channel, the concept of anti-SLAP legislation and things like that.
When you hear Ron and others refer to the Unruh Act, that's a law in 1959 in California that was written in response to the blacklist. It said, hey, especially because the blacklist affected the movie business and it's California, it said you can't fire people or otherwise harm them in their work based on their politics. That is the law that's so key to this. And it's funny that it's being used by the very people who put it in to go after people like this. It's, in other words, it's be careful what you wish for. Someday it might come back to bite you in the butt.
In other words, the Unruh Act was meant to protect commies.
Right.
Well, in that case, I do want to ask, since Disney is essentially arguing against that bit of legislation in the state of California here with their claim here, if this goes in Gina Carano's favor, is there a possibility that it will set precedent against that act?
So the court makes it very clear that Disney's motion does not argue that the Unruh Act is unconstitutional. Rather, it says it doesn't apply here because Disney is in the expression business, and therefore defendants sued under the Unruh Act, if they're in the expression business, should basically be exempt for any anti-discrimination claim if they can plausibly allege that their expressive rights or their associational rights, two different First Amendment concepts, are affected by the employee. The court makes a very good point in a really cool footnote saying that there is no reason to accept, and I love it. I mean, I just love this. You want to go to page 17?
Yep, sure. Let me bring that up.
It's really worth going through with everybody because, given I know that you guys are a little bit more attached to the entertainment business than I am, but I think you're aware as I am of how these people think that they are just too good for the rest of us. Thank you. So again, Disney says that their message, their ability, their message, because they're in the message business, anyone that they associate with, anyone who have casting decisions, people who are basically artistes, creators, should not be subject to this. And they say, don't worry, Judge, this is not a big deal. We're not making an exception that would swallow up the rule, because it only applies to us privileged members of the creative class. And the judge says, I'm not. And the judge did not have to say this, but she says, defendants have not sufficiently demonstrated that this limitation is a meaningful one. If, as defendants urge, courts must defer to employers' accounts of what does and does not impair their expression, there is no reason why an engineer, accountant, secretary, or janitor employed by defendants, who by virtue of their employment with defendants are at least peripherally engaged in creating speech, might not be subject to a similar argument. Similarly, many entities outside of the entertainment industry create speech in some form, rendering defendants' proposed non-expressive employer category tenuous at best.
Yeah.
Now, the court does go on to say, to acknowledge, and this is something we've talked about before in panels where you and I have both been present, Jonas, there is, when it comes to casting decisions, definitely law that says, to the extent that a casting decision has an effect on the message, we're going to defer to the casting decision, because that is the right of free expression and perhaps even free association, but more like the free expression prong that we're not going to get involved with. At that point, the state's interest in prohibiting discrimination takes a backseat to the free expression. That's not what's going on here, because, and again, this is all stuff we anticipated. Nothing that Gina Carano did had anything to do with the message of the program.
Now,
entirely extracurricular.
And yes, please, everybody go over to, first of all, we got the Coleman Nation podcast, and Ron himself has a channel that hosted our response to the Black Girl Gamers threat of lawsuit there. Everyone should go check that out, not just as That Park Place fans.
And tonight also is the debut, by the way, of my new stream with Danny on Direct.
Excellent.
9 o'clock Eastern.
9 o'clock Eastern. All right, everybody.
I will
check
be
that out.
distributing a link later today.
Notifications on. And of course, the best Ron Coleman, in my opinion, is the Twitter Ron Coleman. I love your X feed. Now, what I want to point out here is something that's also been brought up as detractors of this lawsuit have said, well, if Gina Carano wins this, it will set some kind of precedent to where Disney is unable to cast, let's say, race blind casting, politically blind casting, gender or orientation blind casting. This is something that I think is well protected within the bounds of reasonableness and artistic expression. So I'm just trying to say that to make it clear to our audience and correct me if I'm wrong.
Right. Agree. The court makes it clear that we're not talking about casting. And also people should understand that a decision by a single district court is not binding on any other district court, even the same court, even the same judge. I mean, it technically not binding. But when you have a new area of law such as this is, you'll notice that the vast majority of the cases cited here are from within the last 10 years or so. Some of them are even within the last 2 or 3 years and refer to the cancel culture phenomena that have been litigated. It is fascinating, and the judges are the ones making a lot of these decisions.
Well, of course, we talk about the Overton window a lot. Before we say that, the judge has used one of my favorite 3 words here together at the end: tenuous at best. That is wonderful in a legal and argumentative standpoint here. The thing that I want to point out, that the cancel culture and that whole thing, and yes, cancel culture does exist, and sometimes it can result in people getting other jobs, let's say on the other side of the political divide here. But people said, obviously, Gina's not canceled because she went over and got a movie with the Daily Wire, a 3-picture deal, if I'm not mistaken there. But the Overton window here on what is, quote unquote, reprehensible, as Lucasfilm would like to call it, shifted so far to the left that even suggesting the idea that we need to be nicer to each other. Look at what happened over here historically. Don't you all want to be nicer to each other? Become some kind of endorsement of anti-Semitism. It's patently ridiculous. Again, to go back to this, my favorite 3 words in the document here: tenuous at best. But here we are. The Overton window shifted in a way that it should not have been. And I actually wonder if the events of, let's say, Saturday of a few weeks ago might have shifted it back here, as we've all maybe had a cup of cold water thrown on the nation.
All I know is if I ever am foolish enough to write my autobiography, that's going to be the title. Tenuous at best. I love it.
Mine would probably be, where am I supposed to stand? Okay, so there is, of course, this is the most beautiful part of this entire moment here. But Ron, do you have any other segments or sections that you want to point out? You're the expert here. We want to defer to you.
I'm just looking at my notes.
I have a question for Ron.
Yeah.
It doesn't seem in this, as they describe it, that Disney even attacks any of the facts as presented here. They strictly say, yeah, maybe all that happened, but we've got this tenuous at best free speech right that negates all of that.
Well, Lou, they have to say that.
But they can't say all of her story. This part's not true.
Not an emotion to dismiss. No, not an emotion to dismiss.
Okay.
Although, again, sometimes they do anyway, and courts usually throw it away. They don't always throw it away. You're supposed to accept all the allegations as true. Although there are 2 times in the decision when the judge wags a finger at Disney for saying, you want us to accept your version of events, even though they are pleaded contrary to your version. That's when Disney claims, A, we fired her because of this associational risk. She's such a terrible person, not as retaliation for her political views. First one would be conceivably legal. The second one, illegal under California law. And number 2, the idea that they would have lost out. It would have harmed them to have continued in a relationship with her. The court, look, the Carano complaint is well pled.
Yeah, and I think that section about it would have harmed them is negated. I mean, this is just me. Obviously, this has to go to court and everything. But that part where they talk about how she was the most engaged in social media character of anybody on the show.
And they were going to spin her off into her own episode.
Right.
This is something we've seen with our own eyes, and Disney has probably contributed to the popularity of the character by making her more scarce. I will say that. But at the same time, we know that at fan events, we've got a blurb that will be coming up in an article sometime soon. Let me see if I can pull it up here. That Park Place reporters have witnessed events where autograph lines for meeting Gina Carano were longer than event headliners. In one instance, the only lines at the event that were equal were voice acting legend Peter Cullen and Darth Maul actor Ray Park. At the time, Cullen and Park's lines had built up in anticipation of their pending arrival, while Gina Carano had already been signing for 2 hours due to requests from the venue to arrive early and begin signing. While Giancarlo Esposito from the upcoming Captain America Brave New World, and of course Breaking Bad, had a respectable line next to Carano at Fanboy Expo in Knoxville, Carano's signature and photograph lines were well traveled throughout the weekend. Gina is very popular, and lines are sparse for some of the other actors. Other actors had breaks. Other personalities had breaks. You should have seen the poor Muppets people just across the way.
Jonas, that doesn't mean that Disney can't prove that it was still an associational harm to employer, because even if the fans like it, it's kind of like the 2020 election. Okay, Donald Trump could get tens of thousands of people to come to a rally, and Biden, couldn't fill up a senior citizen's basement, but that doesn't necessarily mean that you get the results that you want. It might be that Disney will be able to demonstrate that our finance sources and our constituencies told us that they would be adverse actions if we continue to work with her. That doesn't necessarily get you off the hook under the Unruh Act, because by that logic, again, assuming the Unruh Act really is constitutional, by that logic, you could say everyone told us that if we hire communists, we're not going to be able to,
right.
We're not going to supply you with popcorn anymore. It's problematic. I mean, we are talking about the conflict of 2 social goals that legislators and drafters of constitutions have decided should be pursued. And at some point, there are going to be tenuous, to use that term again, distinctions that are going to have to be made. Lines have to be drawn.
Ron, I have a question about one part of this case that really has always interested me. And that is how her agent and her entertainment attorney both dropped her like a hot potato when this thing happened. And whether they now, because this is going forward, will wind up being called to testify to certify that it wasn't because of any pressure from Disney. And if it was, First of all, are they liable for, I don't know, a discipline from the bar or anything like that? And secondly, what will it send as a message to everybody else who's been pressured like that, which is virtually every agent and entertainment attorney at one time or another in their career?
The answer is yes. They are going to be required to testify. They will be subpoenaed and they will testify. And if they testify truthfully and not only testify, but also produce documents pursuant to a document subpoena to a third party, if they can document or orally testify about who pressured them and how, or whom else they know who was similarly pressured, discovery could continue by calling on those people to testify as well. So this is a huge can of worms.
Yeah.
Although, again, given the virtue perception bubble that these Hollywood people live in, there's nothing about this that any of them would find embarrassing.
That's a very good
I'm
point.
asking, is it not embarrassment, but if it's an attorney, is he subject to some kind of discipline for representing not his client, but the people pressuring his client? I don't know.
Well, he quit. He quit. You can always quit representing a client.
Okay. All right. Yeah. Because it occurs to me they may not have documents overtly. It may have just been a phone call, but there may be stuff within the Disney documents saying, hey, we better call so-and-so and tell him to get off this.
Well, it certainly doesn't reflect well on him. When I say you can quit anytime, I don't do that.
Right.
I've been thrown out of law firms rather than abandon my clients more than once.
That is a story I would love to hear one day. We do have a great question here from Richard Waring for $4.99. Is disclosure one way for Gina to get mails and such, or does Disney get to ask Gina for all of the emails she has to find out what she has against them? A brief explanation of discovery would probably be in order.
So under American discovery, this is true in Europe also. I just actually read about the Irving trial against Deborah Lipstadt. They have discovery in the UK as well. In continental Europe, not nearly as much, and other parts of the world, not nearly as much. But in the US, the discovery is the most invasive. Both sides have to produce all relevant documents that could bear on any claim or defense. It's your job as the advocate to make sure that your adversary does that. People are often, dismissive of that. They say, oh, they'll just delete them. Believe me, that is a much, much bigger deal than you think, especially in the digital era. When I first started out, we did document review. We would be sitting in conference rooms looking at thousands upon thousands of documents that were photocopies of memoranda that were in files. And you didn't know how many photocopies existed, but you sometimes had a pretty good idea that there was just one copy or just three copies of a given document based on document retention policies, based on who was CC'd and that sort of thing. And it was possible to disappear a document. It was highly unethical, and you could get in a world of trouble for it. Enron, the whole thing, Arthur Anderson. So this stuff does happen. But Richard, yes, both sides have to disclose everything that could bear on the case to each other.
Now, that's a perfect answer. There's also this from Industrious Bear, and watch out for Brady violations. What does that mean?
Well, here's a story of a man named Brady. Brady violations are in criminal procedure when the state, the prosecutor, has information that could be probative of what's the word I want?
Exonerating?
Exonerated. Yeah. Get you off the hookative. Or that could be useful for the defense. Criminal discovery is much less is traded. In fact, a criminal defendant doesn't have to give the state anything. On the other hand, you have search warrants. So they just usually go and take what they want. Let's not get involved in criminal defense, criminal law, because I don't practice in that area. But yes, that does happen. If the point of that question was to talk about the disappearing of evidence or exculpatory evidence, that happens a lot in the criminal context, because unlike in the civil context, there's virtually no accountability for prosecutors. They get away with all kinds of things.
Yeah, that's the kind of thing. I think that'll be coming up in the coming days as more information comes to light. I mean, it would be if someone had held on to something that would exonerate a person if they were on death row, or decided to extend sentences in order to keep them in the California labor system.
Who would do that?
Longer than they were due. That would be despicable.
Somebody who cackles only would do that.
That would be
anyway.
Yeah, that would be criminal, and I would say that would be approving of slavery. Things like that. That would be a shame.
Not if she were a Democrat. No, that would be fine.
This fight for truth is just beginning, and I don't know what the next steps here are. Ron, did you have any sections you wanted to talk about? Because I had a bigger question for you.
Okay, let's go straight to the bigger question, because I do have a call coming up. So let's get there, and then I'm gonna ease out.
Oh, all right, and thank you for your time so far.
Oh, my pleasure, of course.
Okay, this thing goes to Discovery. Obviously, Disney wanted this to be dismissed, so they don't have to do anything for it. They're probably going to be weighing how much settlement they want to do, considering the public nature of this case. The stock price, it's up to $90.37, which is still in the toilet as of the last 3 months. It was at 123. Gina wants her day in court. How likely is it for this thing to be televised so that we can all enjoy the mutual search for truth, perhaps here on That Park Place or on the WDW Pro channel?
0%.
Oh,
yeah.
No.
Yep.
Yeah. Federal courts do not have cameras.
Zero.
And I'd hate to put somebody of my friends out of business, so I'm not going to say what I really think about cameras in courtrooms.
No, that's okay.
What I have to say doesn't really make a difference. But no, that's not going to happen. But as we have seen in other federal trials, or in the New York Trump criminal case, people go into the courtroom, they report in real time. It's a little bit less of a circus if you don't have the cameras. But from here to trial, I mean, what's going to be much more interesting is going to be the stuff that's going to come out between now and trial, and now including a summary judgment motion if it's not settled. This is a really, really good decision, and people keep asking about precedent. It's an important decision. It's a very, very sound, well-written, well-balanced decision. And if anyone in the legal commentariat has commented or does comment to the contrary, I would be very interested in seeing what that person has to say, because I don't see where there could be a hole in this.
Do you get the sense from the judge that, I mean, from this 23-page order, essentially, do you get the sense from her that she's going to strongly consider, Gina's case, and that she's not going to, as we're worried about her getting her fair day in court? Do you get a sense from this that she's heading in the right direction?
Yes, and I think she's going to be fair to both parties. I mean, this is a high-profile case. Disney is a powerful company, and a federal judge is supposed to be less amenable to outside pressure, but there is a cultural, sociological bubble that they live in as well. I think this judge, this is a case that Disney's lawyers have to worry about whether they're going to be heard fairly. He told them what they're going to have to prove. She does not like what she has seen so far, and well, indeed, might she not. The fact that someone coming up from her background coming to this fair of an opinion really warms the cockles of my heart and gives me the strength to go on. If it didn't come from her, it would come from someone else.
Yeah.
But in this case, it comes from her.
Before Ron gets away, I have one last question.
Okay.
There's been a lot of talk about how what comes out in Discovery may lead to either other cases or some kind of class action if it's proven to be a company-wide policy and not just let's get Gina because we don't like the cut of her jib. What is the likelihood of that, do you think?
Well, those are two different likelihoods.
Right.
I think there's a distinct possibility that this could be a link in a chain for more individual claims. Class actions here strike me as a bit of a stretch.
Right.
Because in a class action, what's the typical class action? The same exact damage happened to every member of the class. We all used the same kind of tire. We all bought the same product. We all spent the same amount of money per widget.
Right.
Here, it's a very individualized kind of injury, if there's any injury at all. She is the perfect plaintiff, just about, for this case.
I have to ask, on the subject of class actions, would a good example of a class action suit be the one against Disney right now and all the ladies saying that they were held back and not properly paid because they were women?
Let me throw this from Jim Jam for $5 on top of that. What can employers take away from the results of this case? Will it change how they see employees' social media or DEI-centric training? So I'm going to combine this in there. Jim Jam, great question.
Well, I think all these questions are, I don't know a culture where that case stands. It is true that when you have a pay discrepancy case based on disparate income, disparate effect of discrimination, that can proceed as a class action, but that legal test, disparate impact, is dying a slow death because it's really not a valid. Women and men are not the same. And are often reasons that have nothing to do with their sex, but have to do with their career paths. So I'm not gonna weigh in on that case. Jim Jam's case. What Jim Jam's question? What are they going to take from this? They're going to take from this that they're going to have to be a little bit sneakier than even Disney was here. And what Disney was here was not very sneaky at all.
That's the thing.
Well, they announced it.
They as much as announced it because virtue signaling requires that extremism in defense of virtue never be a vice. Channeling a little Goldwater there for you, Lou.
Yes,
now,
absolutely.
I do want to throw this in here. Packing protons for 5. Ron, chances of Bob Chapek testifying? Probably been asked already. Chapek was the CEO at the time. I do believe the email chain included Bob Chapek.
Yeah.
So there you go, packing protons. I would say
See
that's...
ya, guys.
And we've been told that NDAs don't prohibit criminal testification. Does it apply in civil like this too?
Yes, it does. And the NDA will not. In fact, every NDA just about will always say, unless pursuant to a court order,
oh, great,
thou shalt not.
And I just have to say that Ron agreed to a 1/3 of the time that he's given us today. So thank you, everyone, for all of the kind words to Ron. He deserves every one of them. Thank you for being here, Ron. You're a saint.
Good night, everyone. Good night. I'm used to talking to you guys at night,
as we say in Hebrew.
Yep. Thank you, Ron.
See you.
Everybody needs to go check out Ron Coleman on YouTube. If it's a muscular black man, then you might be on the wrong channel.
But that's a fine channel.
I love Ron. Absolutely love Ron.
If you'll permit me, Jonas, I want to highlight one thing here from this order that was given out by the judge in denying the dismissal here. Hollywood Reporter has a section here of what Disney tried to argue before the judge. So Disney argued that there's a First Amendment right to choose employees who properly convey their values, even when these choices would otherwise violate state anti-discrimination laws. It cited the Supreme Court in Boy Scouts of America v. Dale, finding that the organization's decision to fire an openly gay assistant scoutmaster is protected under the Constitution. Constitutional right, the court concluded, shields the scouts from violations of New Jersey discriminatory laws. So if we refer to the actual order right here on page 14, starting with line 4, here, although defendants engage in expressive activity, including but not certainly limited to producing and disseminating The Mandalorian, this is from Disney's perspective, they have failed to establish that they engage in expressive association. Furthermore, at this stage in the litigation, the court cannot conclude, as defendants urge it to, the plaintiff continued employment by defendants would inhibit or intrude upon defendants' rights to expressive association. As an initial matter, unlike the Boy Scouts or JCs, defendants are not members-only nonprofit organizations. Instead, defendants are for-profit corporations who, as relevant to this lawsuit, employ actors such as the plaintiff, being Gina, as well as administrative staff to create television series and films. Speakers do not, of course, shed their First Amendment protections by employing the corporate form to disseminate their speech, but unlike in Roberts v. Dale, defendants have not identified any evidence in the complaint or otherwise to substantiate a claim that they employ public-facing actors for the purposes of promoting the, quote, values of respect, decency, integrity, and inclusion. Accordingly, defendants' invocation of the supposedly detrimental effects of plaintiffs' mere presence as one defendant's employees lacks constitutional import. That's a pretty stern, like, hey, you don't have enough to substantiate your claim. And who actually made that claim, by the way? You'll remember that the rebuttal that came from Disney's side, was that attorney at the top of the chart there? That's Daniel Petrocelli, right? Oh, man, stacking up the L's as only Daniel can do.
Yeah, speaking up, Northman JH says, is Vash going to be the court reporter for that Park Place? That is a very interesting question.
Because he's absolutely laying around doing nothing right now.
That's right. He's got nothing to do.
He has nothing else to do.
Maybe he can edit from the courtroom.
I just want to know if we're going to buy one of those cute little court reporter things to type into so that he doesn't have to use his keyboard like a guitar like he does now.
I love it.
I love it.
That was a highlight from our live stream on That Park Place, where the full stream can be accessed by members to the That Park Place YouTube channel. But what about you? What do you think about this very intriguing and fascinating story? Please let us know in the comments below. Like this video if you did like this video. Share us out as it helps us out tremendously against the YouTube algorithm. And thank you so much for watching. T3BO. Please comment, like, and share this video. And don't forget to subscribe to That Park Place Podcasts online.
your source for exclusive content and highlights from WDW Pro, The Pro Show, and That Park Place for all the news that should be fun.